heard the learned counsel for the parties. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner had moved this court earlier in WPS number 4809 of 2021. Where is that order? Order 4809. Yes, 4809 of 2021.
Yes. Page 35.
Seeking a direction upon the respondents to consider the case of the petitioner for appointment on compassionate ground in place of her brother, namely Gautam Kumar. He submits that the foundational background of the case has also been narrated in the order passed in WPS number 4809 of 2021, and ultimately the writ court directed the respondents to consider the case of the petitioner for appointment for compassionate appointment if the petitioner fulfills all the criteria. The learned counsel submits that thereafter the district establishment committee,
Compassionate Appointment Committee.
thereafter the district compassionate committee has taken a decision, and the case of the petitioner for compassionate appointment has been rejected solely on the ground that on the date of death of the father of the petitioner, the petitioner was already married. The learned counsel submits that a reference has also been made to clause 4 of circular dated 1/12/2015. He submits that the petitioner had filed affidavit before the authority, as has been annexed in the writ petition, that she was a dependent on her father and her husband was unemployed. He submits that merely because the impute order has been passed rejecting the claim of the petitioner, merely on the ground that she was married on the date of death of her father. He submits that such decision is not only contrary to the circular dated 1/12/2015, but is also contrary to the judgment passed by this court in the case of Kalyani Kumari Mishra versus State of Jharkhand, passed in WPS number 2818 of 2017, decided on 20/11/2017, wherein it has been held that, wherein it has also been observed that under clause 4 of the 2015 scheme, a married daughter has been included in the definition of dependent of the deceased employee. The learned counsel submits that the reason for refusal of compassionate appointment is contrary to their own circular, and therefore the same cannot be sustained in the eyes of law. The learned counsel also submitted that in the aforesaid judgment, the This court has also considered Article 15 and 16 of the Constitution of India and has observed that any discrimination on the ground of sex is prohibited under Article 15 and 16. He has submitted that married son is not eligible for appointment on compassionate ground, and therefore married daughter can also not be disentitled for compassionate appointment if she continues to be dependent on her father. He submits that the circular has been wrongly interpreted by the respondents. The learned counsel for the respondents, while opposing the prayer, has submitted that the impugned order does not call for any interference. After hearing and has submitted that it has specifically stated in paragraph 23 of the counter affidavit that since petitioner is married, therefore she is not dependent on deceased father.
As per clause 4 of the resolution.
And as per clause 4 of the circular of 2015, the petitioner is not entitled for compassionate appointment. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that it is not in dispute that the father of the petitioner expired while in service on 24/12/2018 and the petitioner got married on 28/4/2017. The petitioner had moved this court earlier for consideration of her case on by the respondents for compassionate appointment in WPS number 4809 of 2021, which was disposed of by the order dated 27/7/2022, directing the respondents to pass a recent order, and the impugned order has been passed pursuant to the said order. The circular dated 1/12/2015 has been brought on record by the respondents. Clause 4 of the said circular gives the list of persons who can be said to be dependent. Clause 4 is quoted as under. Clause 4 within bracket Roman 3 clearly provides that unmarried / widow / divorced / abandoned बोलेंगे परित्यक्त commodity बना दी
Abandoned, or if the husband
Destitute.
is mentally not stable.
परियक्ता किसको बोलते हैं? इसको ट्रांसलेशन देखिएगा, ठीक है? And married daughter who at the time of death of her father is dependent on her father is entitled for compassionate appointment. This court is of the considered view that clause 4 of the aforesaid circular clearly indicates that even if the married daughter, that compassionate appointment can be granted even to married daughter if she is dependent on her father at the time of the death of the father. In the present case, the only ground for rejection of the claim of compassionate appointment to the petitioner is that she was married prior to the death of her father. The materials on record show that the petitioner had filed affidavit before the authority and had asserted that at the time of death of her father, she was dependent and on her father, and her husband was unemployed. This court is of the considered view that the rejection of the case of the claim of the petitioner for grant of compassionate appointment merely on the ground that she was a married daughter cannot be sustained even when seen in the light of the circular issued by the respondents. In the counter affidavit also, the respondents have asserted that the sole reason for rejection of claim of the petitioner for compassionate appointment is that on the date of death, the petitioner was, the death of her father, she was married. This court finds that the clause 4 of the circular has been wrongly applied in the case of the petitioner. This court has also gone through the judgment relied upon by the petitioner in the case of Kalyani Kumari Mishra. Some of the in the case of Kalyani Kumari Mishra, where the claim for compassionate appointment was declined on the ground that the married daughter was not covered under the definition of dependent in memo dated 5/10/1991, which was the earlier circular governing the field. This court has considered the constitutional provision and also the responsibility and the constitutional provisions which clearly prohibits any discrimination on the ground of sex under Article 15 and 16 of the Constitution of India. And it has been also held that once a married son is not ineligible for compassionate appointment, attaching such a disability to a daughter on such a ground is illegal. This court has also considered that under the provisions of Maintenance of Welfare and Parents and Senior Citizens Act 2007, if a son and daughter both have been put under the duty to take care of their parents at the old age, on the death of their parents, they cannot be extended unequal treatment. Paragraph 5 of the aforesaid judgment is quoted as under. This court has further considered the scheme of compassionate appointment formulated by the state of Jharkhand, which became operative from 1/12/2015. That is the present circular. That is a circular involved in the present case, and has observed that under clause 4 of 2015 scheme, a married daughter has been included in the definition of dependent of deceased employee. Paragraph 8 and 9 of the aforesaid judgment is quoted as under. In view of the aforesaid interpretation to clause 4 of the 2015 circular and the read with the judgment passed by this court in the case of Kalyani Kumari Mishra, this court is also of the considered view that the impugn order rejecting the claim of compassionate appointment to the petitioner is cannot be justified in law, and therefore the same is hereby quashed. No other reason has been assigned in the impugned order to deny compassionate appointment to the petitioner, meaning thereby there is no other legal impediment in the matter of grant of compassionate appointment to the petitioner. Accordingly, the respondent number, who will comply the order?
District Superintendent.
The respondent number 3.
4. Executive Engineer.
Executive engineer.
3 and 4. 3 is head of District Compassionate Committee.
Respondent number 3 is directed to give compassionate appointment to the petitioner within the period of 2 weeks from the date of communication of this order. This petition is disposed of.
Pass over case from supplementary list, item 6, WPS 6272
What is this? There is no recruitment process.
That I've seen, but I was not aware. Now the point is not, anyways regularization would not have been, according to me also, because she's not worked for 10 years and she's participated in the examination process, she's extra.
You withdraw and pursue your remedies.
No, there's no other remedy. The only thing I think, is the salary because she has worked, state can't say that I will not.
State is not the person, and the state is not remitting salary to you.
State is not an aided, therefore,
It is aided, but all the salary doesn't go back from the state.
in case of deficit can't. But if it is fully aided, those things are
We
like.
cannot issue such direction because you are not working under against sanctioned vacant post and you have not been inducted as per the process.
That answer I have not. The answer is that the post of principal, and there are judgments to the effect that if the state has a right to make a permanent appointment, then having regard to the exigency of service, state can also make an ad hoc arrangement.
No, they have not. State has not made
The
any
management.
Here
The management.
ad hoc arrangement in the case of minority school.
It continued because without principal they
No,
can't.
principal is, you see, so far as principal is concerned, that is a separate thing altogether because principal itself is a vacant sanction post and the person who will work as a principal
Correct.
is also appointed against a vacant sanction post.
Right. So
But here, her appointment has no basis altogether.
it's only without advertisement. Otherwise, not.
That is fatal.
No, and I'm saying it's an irregular appointment, even if assuming because I have been working as if I have worked, then I'm
There
entitled
is
to the
no
salary.
prayer for your
Salary.
salary.
Yes. I think that.
No prayer has been made.
No.
I have a response to pay salary and petitioner as part of the
No,
discharge.
that is a separate thing. Salary at par is separate from whatever. No, we can't get.
So, may I just suggest one thing that I'll approach the competent authority with regard to my grievances, because
Who would
I
be the
think there is
competent authority?
here in this case, either it should be the respondent number 4 or 5. So I'll approach the respondent number 4 through the respondent number 5 through the school. I'll approach the respondent number 4 because whatever your lordship is right that those facts are not there. If I have worked, my only concern is I have worked and you have acknowledged my presence as a principal for the last 8 years. You allowed me to discharge my functions, then I'm entitled to the salary.
Heard the learned counsel for the parties. After some argument, the learned counsel for the petitioner submits that he may be permitted, the petitioner may be permitted to approach respondent number 4 through respondent number 5 for redressal of his or her, for redressal of her grievances.
In accordance with
Accordingly, this writ petition is disposed of. The petitioner may do the needful in accordance with it.
great. एक जगह ही हो गया था.
Pass over case, item 36, WPS 6478 of 2023.
Same order, you have not represented?
Lord, I have not represented.
Same order?
Same
Same
order.
to same?
Same.
Anything to be changed?
Lord,
You have annexure number or anything? You will go to respondent number 1.
respondent number 1.
So gazette notification is the same?
Same.
You have given him the order? दे दीजिए भाई, देख लीजिए सेम ऑर्डर हो जाएगा तो
Lord, representation within 15 days, result order within 3 months.
जो है इसमें सो है सेम टू सेम.
Same to same.
Same order कर दीजिए ये. Give you a memo of the case.
From the supplementary list at 2:15, under heading for admission, item 1, WPS 305 of 2023.
Who's for the petition? Yes. Yesterday somebody else was appearing. Are you there? Class 4 or class 3? Which class?
Class 3 employee minutes. Plus, can I, with your permission, if I can only revise the facts minutes? Because there's only two annexures, I'm agreed by annexure 2. And I'm agreed by a non-cryptic order, which is passed after my superannuation, long after my superannuation. So my case rests on two footings. That the recovery matters, because I have also come across one of the judgment, because I was always trying to distinguish my case from this judgment, which is being relied upon my learned friends. Plus, I say, unless that,
You just give the facts.
yes, ma'am.
Counterfeit?
Counterfeit malice. We have also refuted the stand. We have also filed our rejoinder with malice.
Not so far,
He says that he is in class 3.
Yes, ma'am.
we are saying that he
On
belongs
instructions?
On
You are
instruction.
saying what?
group B,
Group B would be which class?
class 2.
There is a very serious dispute about it. How do you say?
No, this is on instruction. I say because
On instructions mean what? Your client is giving you wrong instructions.
malice- the class.
No, why I'm saying
Because my
Class
post-
will matter because your Rafiq Masi is class
Yes,
4 and class
3
3.
and class 4.
So,
But then again, there are other points also. Just not class 3 and class 4. There are
so
5.
we'll take that it is class 2 and
Because-
exclude Rafiq Masi.
Because
Should I?
because I was working on the post of cooperative
I
extension
just do
officer.
not know. I just want to know from you. Will I take class 2 or class 3?
Yes, class 3 post is my instruction malice. Because it was specific query of this court whether what was the post he was actually working on. Now, they disputed that he working on a class 2 post. So now, if not this hurdle is passed, like we cannot go further now. And anything which is I speak against the record, it always come against me.
Certainly it will go against you.
Yes, Malas. So I will need to proceed with precaution, Malas. Because class 3 and class 2 is entirely
Therefore,
changed the
you
game
will not
altogether.
proceed. You file an affidavit. I will record your statement that he has given you instructions that you are in class 3.
Let me file an
And then
affidavit.
you file your affidavit.
Yes, ma'am.
You also file your affidavit.
must.
Let me file an
This
affidavit.
place, the
then.
rules.
Be very sure about
Yes,
it,
yes,
whatever
ma'am.
instructions have been given
Yes,
to you.
yes, but that is why on instruction, let me file an affidavit
You
stating
file
this.
an affidavit.
May I
So
just
that,
show-
then let me compare my case with Rafiq Masi's case, Malas, because it will be essential then. Malas.
may I just show the rules, my lord, which will make clear that he belongs to group B. Not the.
No, you file an affidavit. What
I'll
should
be
I say?
fine.
You do it. The learned counsel for the parties are present. The learned counsel for the petitioner is heavily relying upon the judgment passed by the Honorable Supreme Court in the case of State of Punjab versus Rafiq Mashi, reported in bracket 2015 bracket close 4 SCC 334. On the other hand, the कल का ऑर्डर नहीं है सर कल का ऑर्डर कहाँ है Where is yesterday's order? मंगाइए तुरंत मंगाइए. The learned counsel for the respondents has submitted that the said judgment has been subsequently distinguished
Must.
in the judgment passed by the Honorable Supreme Court reported in bracket 2016 bracket close 14 SCC 267. And the undertaking given to the employee at the time of granting any benefit is binding on the employee, and it is not open to the petitioner to contend that the recovery of any amount which has been wrongly granted to the petitioner cannot be made. He has also submitted that that the petitioner belongs to
Group B.
Group B, which is under class 2 post, and the judgment passed in the case of Rafiq Mashi was relating to was primarily relating to class 3 and class 4, and otherwise also the judgment of Rafiq Mashi will not apply to the present case. To this, the counsel for the petitioner on instructions from his client has submitted that the petitioner was working under class 3 category and not class 2. Since there is a dispute in connection with the status of the petitioner which has a bearing in the present case, the aforesaid instructions which has been received by the petitioner, which has been given by the petitioner to the council, be placed on record by filing an affidavit. The respondent shall also file an affidavit with regard to the status of the petitioner. The needful be done by Monday. The needful be done by Monday. Post this case on Wednesday, on Tuesday. This is fresh filing admission.
This is admission.
Admission.
Item 2 WPS 378 of 2023.
I had taken this matter yesterday.
Yes.
This was in regards to BC2 and BC1 shifting of the categories. The other side had sought time to go through the orders
Yes.
passed by the coordinate bench.
You have seen the judgments?
But I have seen your lordship, only your lordship slightly, your lordship at present your lordship. When the order was passed by your lordship in division bench, your lordship, at that time point of time, the selection process for the appointment of the constable was not initiated. Now on 20th of December, your lordship, the advertisement has been issued. Now there is no vacant post. By the advertisement number subject to correction by learned head, by the advertisement number 17 of 2023.
So that has been issued. I'll not say that the same has not been issued because I was arguing a matter connected to that itself today before the Honorable Division Bench number 2, Your Lordship, in which we have prayed for stay of that particular advertisement itself. But as on date, Your Lordship, those vacancies are still there. It cannot be said that the vacancy was not there.
All have been
But vacancies have been advertised.
It has been advertised, Your Lordship, but it has not been fructified in form of any appointment.
That's right. But once the vacancies are advertised, out of same very vacancy, how any appointment can be made?
But my writ was filed prior to that, Your Lordship, prior to the issuance of those vacancies, Your Lordship. My writ was already pending as of that. And Your Lordship, as on date, Your Lordship, if I may just try to convince, as on date, there is no impediment, Your Lordship, if an order is issued, that particular one post, it's just a matter of one post. And Your Lordship, once a judgment was passed in the year 2022, then even Your Lordship, the respondent could have taken a suo motu decision to correcting it and applying it for all.
Give us the date, when was that circular issued and when was your advertisement issued?
Yes, Your Lordship.
Date of advertisement?
Lordship, exact date of advertisement, Your Lordship, I'll not be able to say. It is year 2015, but the last date for filling of forms, Your Lordship, I can
Give us the
provide.
date.
16/9/2015, Your Lordship.
This is
Sorry,
para teacher.
please no.
This
Please
is
no.
para teacher.
Please no. No, constable.
Constable, okay. Sorry.
30 no 15. 39/2015.
39 2015 is the last date for filling the forms.
Filling of the form.
Okay. Then
And the notification which your ladyship had just asked, that was issued on 23/7/15.
23/7/15 is the notification
Notification.
by which the class was changed.
The class was changed.
Just a moment. And your certificate was issued when?
My certificate.
It was changed from BC2 to BC1.
BC1. It was issued in the year 2016, Your Lordship. 14/12/2016. Because the advertisement provided, Your Lordship, that at the time of filling of the forms,
Just a second. The class certificate initially was issued when?
it is dated, Your Lordship, 14/12. Issue date is 20/12/2016.
2012
2016.
2016 caste certificate.
Caste certificate.
Showing your caste as
BC1.
Teli,
Yes, Your Lordship.
Teli but BC1.
BC1.
As per the earlier circular,
As per the new circular.
BC1.
BC1. BC2 से BC1 हुआ.
All right, BC1.
Yes, sir.
All right, BC2 का circular का date? When this was there under BC2,
Sorry, Rucha.
it must have been by virtue of some notification under
Yes, sir.
BC2.
23/7/15 is the notification date. I just indicated that. But
No,
I have given a
just
list
say-
of date also for
Please
it.
give me the list.
I had given it yesterday. Lordship, I have indicated that 30/9/2015 was the last date for submission of the online application form. On 23/7/15, this change had taken place.
It was prior to that.
Yes, it was prior to that. And there is one other date, Your Lordship, though, which I should have mentioned, that the advertisement provided that the person who is applying should be in possession of the certificate which is issued after 31/3/2015. That has not been mentioned in my list of date, Your Lordship, but it should have been. 31/3/2015 is the date after which the certificate, which is to be presented at the time of verification, should be dated after that particular date, 31/3/15. And Your Lordship, the petitioner has got more marks than the last selected candidate in all three categories, that is general, BC1, BC2. So statement from the not responded by you.
You have not filed any counter application.
Yes.
My lord, we have filed.
You have not given the basic detail.
What would I?
He selected, the petitioner was getting more marks. He got
No,
more
my
marks.
lord, in his category, BC1 and BC2. But your lordship, so far unreserved category is concerned, he is overage.
He's overage.
He is overage. I have made a statement.
Just-
about it.
But under BC1 and BC2 category, male or female?
Male.
Male.
BC1 and BC2 category, he has got more marks than the
Yes, Your Lordship.
last selected candidate.
Lordship, my statement in paragraph 38 and 39 is that BC 38 and 39 of the writ application, that BC1 category last selected is 201, BC2 is 204, general is 210, and I have got 228. But only
But you are
relaxation.
overage.
About 8 days.
By 8 days.
8 days or 8 months, when just indicated. I am overage, admittedly I am overage.
I have made a statement.
By 3 months and 8 days. Yes, sir, paragraph 38 and 39.
When did they reject your category, your candidature?
RTI reply is dated 24/11/22.
When did they actually reject it?
Lordship, when the final merit list was issued,
When
Your
was
Lordship,
it?
I was not informed in regards to that.
When was
I'll
it issued?
just- Lordship, it is somewhere in December 2016, Your Lordship. Exact date has not been provided because it was uploaded on the website. I was informed under RTI, Your Lordship, in the year 2022.
You slept over the matter from December 2016 till 2022.
Lordship, I had asked under RTI, only thereupon I was informed that this is the reason why I was not
When did
showing.
you apply under RTI?
18/11/2022.
18/11/22 and 24/11/22 is the information thereof at page 138.
Why did you sleep over your rights for 6 years?
Lordship, the contention that the petitioner has tried to make in the writ that he was pursuing the matter with the respondents.
What pursuance?
Lordship,
When
there
the
is
final
no-
result
there
is not there.
There is no other thing, Your Lordship, which is there on record. I cannot say that which is not there on record. The only thing is that at paragraph 35 and 36 he has mentioned that he had filed an application under RTI and he was informed that his case has been negated on this ground that there was a shift and he had not submitted a certificate of BC2 category, which he couldn't have.
Where is that information under RTI?
Annexure 11, page 138.
130?
138.
Kindly read it.
Yes, sir. निर्देशानुसार उपरोक्त विषय आपको सूचना आवेदन की तिथि 18/11/22 के संबंध में संबंधित प्रशाखा से प्राप्त सूचना कंडिका निम्नवत है। कंडिका 1, झारखंड आरक्षी प्रतियोगिता परीक्षा 2015 में अत्यंत पिछड़ा वर्ग 1 पुरुष कोटि में अंतिम चयनित अभ्यर्थी को प्राप्त अंक 201 तथा पिछड़ा वर्ग 2 पुरुष कोटि में अंतिम चयनित अभ्यर्थी को 204। कंडिका 2, अनुक्रमांक सच एंड सच रघुवर प्रसाद गुप्ता का प्राप्तांक 228, दैट इज द पिटिशनर। कंडिका 3, रघुवर प्रसाद गुप्ता द्वारा अपने आरक्षण संबंधित दावे के समर्थन में विज्ञापन के शर्तों के अनुसार मान्य जाति प्रमाण पत्र
Where is
समर्पित।
the condition in the advertisement that this caste certificate issued prior to 31/3/2015 was to be considered?
Yeah. Page 44 onwards, Your Lordship, if I may show. Just two clauses, Your Lordship. 8, subclause 3, and on page 44, 45, subclause 3 again. 8, subclause 3, firstly, if I may place, Your Lordship. Page 44.
44. Yes.
झारखंड सरकार द्वारा लागू आरक्षण संबंधित सभी नियम प्रभावी होंगे। आरक्षण का दावा करने वाले झारखंड के स्थानीय निवासी उम्मीदवार को निम्न प्रमाण पत्र आयोग द्वारा प्रमाण पत्रों के जांच अवसर पर समर्पित करना अनिवार्य होगा। एंड नेक्स्ट पेज, अत्यंत पिछड़ा वर्ग, द फर्स्ट वन इटसेल्फ, अत्यंत पिछड़ा वर्ग अनुसूची 1 तथा पिछड़ा वर्ग अनुसूची 2 के लिए दिनांक 31/3/15 के पश्चात विहित प्रपत्र सच एंड सच में निर्गत जाति प्रमाण पत्र मान्य होगा।
It is to be issued after
31/3/2015.
No cutoff date. as
No cut off it. It is just कि इसके बाद का होना चाहिए. And it is to be submitted only at the time of verification of document, not prior to that. And same and similar with the clauses in the other matters also, Your Lordship. The coordinate bench in the case of Love Kush was in regards to the same very advertisement also.
So some order has been passed by coordinate bench.
Coordinate bench also, Your Lordship. I had given a single judge's order, Your Lordship.
LP I have. I have
WPS?
this writ
It was a batch of matters, Your Lordship.
decided when?
Justice.
On 9th of 7th of December, Your Lordship.
Where is the finding? What is the direction issue?
Your Lordship, actually, नहीं, writ वाला. Justice. ये दो. Paragraph 17. As a squatter of the aforesaid rules, guidelines, judicial pronouncement, this court is of the considered view the case of the petitioner be reconsidered for their appointment, taking into account that they have obtained more marks than the last elected candidate in respective categories. As submitted by the learned counsel for the party, the seats are still lying vacant. The respondents are directed to consider the candidature of petitioners under BC1 category in view of the caste certificate issued to them. And if they have obtained more marks than the last elected candidates in the said category, the issue of appointment letters to them within a period of 8 weeks. After the LPA's order, Your Lordship, considering the LPA's order itself. Ranjit Prabhakar.
Apart from saying that there is a fresh advertisement, you have nothing to say?
But not only, Your Lordship, I will clarify 2 points, Your Lordship. What he has argued, Your Lordship. Regarding, Your Lordship, cut-off date 31/3/2015. And secondly, Your Lordship, what was the requirement in the advertisement? But can you have a look to page 43, that is part of the advertisement.
Yes.
Only 2 clause. Clause 4. परीक्षा के लिए आवेदन देने के पूर्व यह सुनिश्चित हो ले कि वे विज्ञापित पद की पात्रता के विषय पर प्रकाशित सभी शर्तों को पूरा करते हैं। परीक्षा में बैठने की अनुमति पूर्णतः औपबंधिक होगी। परीक्षा के लिए प्रवेश पत्र निर्गत होना प्रमाणित नहीं करता कि अभ्यर्थी विज्ञापित पद पर नियुक्ति के लिए चयन हेतु निर्धारित पात्रता पूरी करते हैं, क्योंकि आयोग परीक्षा के बाद अपनी सुविधा के अनुसार किसी भी समय अभ्यर्थियों की पात्रता से संबंधित प्रमाण पत्रों की जांच करेगा। That was the only requirement, Your Lordship, that the candidates should ensure that they are eligible for consideration and they are possessing all the required qualification and condition. Next, Your Lordship, kindly turn to page 44.
Yes.
मानव आवेदन में नियत प्रविष्टि के अधीन इंगित आरक्षण का दावा नहीं करने पर आरक्षण का लाभ नहीं मिलेगा. Then I will show my from counter affidavit. इसके बाद देखा जाएगी झारखंड क्लॉज 3 इसी में पेज 44.
Page number 44
44 itself your lordship.
in the writ petition.
नहीं हाँ in the detail.
This 44 I've seen.
क्लॉज 3 your lordship. झारखंड सरकार द्वारा लागू आरक्षण संबंधी सभी नियम प्रभावी होंगे. आरक्षण का दावा करने वाले झारखंड के स्थानीय निवासी उम्मीदवार को निम्न प्रमाण पत्र आयोग द्वारा प्रमाण पत्रों की जांच के अवसर पर समर्पित करना अनिवार्य होगा. My lord, clause 4 says your lordship that you will have to indicate your fill up entire thing in the online application for your lordship. And this clause says your lordship that you are required to produce the documents your lordship.
So why have you mentioned that the caste certificate issued after 31?
My lord, that, I am coming your lordship. I am coming for so that your lordship I am showing this clause your lordship. Why the same has been mentioned your lordship? Because your lordship, there are criteria for BC1 and BC2 your lordship, creamy layer, and it is your lordship review for every 3 years your lordship. Limitation your lordship, the ceiling limits has to be considered and it is enhanced and reduced your lordship. For that purpose your lordship, if the caste certificate would have been before the 31/3/2015, the same would not have been valid
You
for this.
don't put a cutoff date, right? You do not say that on a
My lord, for the
particular-
cut-off date, although I should not argue because that has been considered in. My lord, the cut-off date your
You have
lordship.
not gone in Supreme before Supreme Court.
My lord, state we have because my lord, Ashok sir.
Ranjit Prabhakar has been confirmed by Supreme Court also.
Ashok Sharma case, your lordship, 75 Supreme Court, your lordship. That says your lordship. That your lordship, and that has again reiterated by the Honorable Supreme Court in Divya case, your lordship. That when there is no cut-off date mentioned in the advertisement for submission of the certificate, the last date for submission of the application form will be the date by which your lordship the candidates will have to acquire all the qualification and certificates. That is the recent judgment of the Honorable Supreme Court.
I may also indicate this.
You issued the advertisement in 2015.
I issued.
Last date was, what is the date of the advertisement? You do not know.
My lord, that was your lordship August 2015.
Let us take it August,
August.
right?
Uh.
Okay. And then in August you say that the last date of submission of form is
39/2015.
You totally ignore the circular issued by the state government on 23/7/2015.
My lord, how I can.
And you say that caste certificate issued after 31/3/2015 can be taken into consideration.
My lord, I have said your lordship, but my lord, kindly consider one thing, your lordship. When the caste was changed in July 2015, your lordship, prior to issuance of the advertisement. My lord, if the same would have been changed, your lordship, after issuance of the advertisement, your lordship, then the circular dated 18/12/2015 would have come into play, your lordship. That is on the record, your lordship. By which your lordship.
And in these two cases which has been decided by this court,
My lord.
the advertisement was
Same. No. One was your lordship forest guard and one was your lordship for constable.
But so the coordinate
Present.
bench's judgment,
That
paragraph
was
4,
forest guard. Forest guard.
paragraph 4, this advertisement of 415 itself was an issue.
One your lordship Pushpanjali Kumari in relation to the instant selection process and Ranjit
Love
Prabhakar
Push.
is your division. and your lordship the Ranjit Prabhakar in relation to the forest card.
I want to know that whether the circular was issued after the issuance of advertisement in both the cases or before issuance of advertisement in both the cases.
Before.
In both the cases which has been decided by LPA.
Madam, that will have to be certain by the
Lordship, if
state.
I may just indicate, coordinate bench's judgment, if your ladyship is having a look at, kindly come to paragraph 4.
You see, coordinate bench judgment, I can always differ.
Yes, absolutely.
I just want
I'm
to
just
know
showing-
what is binding on me is the LPA judgment as of now.
LPA.
Right? I just want to know in the LPA judgments, the advertisement was issued after the circular or before the circular?
Before the advertisement was issued after the circular.
In LPA number 675.
No, उसमें तो हमको ये
LPA 675/14 June हुआ था तो
that
14 to 22 is the order. What is the date of advertisement?
That is 3 of 14, your lordship.
3
Why
of
not that
14.
3 of
There it
14.
has been mentioned, your ladyship, in
3 of
paragraph
14.
3. Advertisement 3 of 2014 was issued on 5th
5th
November
November
2014 by Jharkhand Staff
And-
Selection Commission.
And the other
And
judgment.
thereafter the
Category was changed.
category was
Post
changed.
of forest
Right?
card.
right.
And what about the other one?
Pushpa
Madam,
Kumari is of 4 of 15 itself, this very article. Paragraph? Paragraph 5.
Pushpanjali Kumari.
Paragraph 5, your ladyship.
Pushpanjali
In the year
Kumari.
2015, advertisement 4 of 15 was issued by the JSSC for appointment of post of constable.
That is in August.
Para number?
Paragraph 5, LPA 338. Paragraph 5. The first line.
Yes.
And
It
your
is the
ladyship-
same advertisement.
Same advertisement. And your ladyship may also know. Now, my serious contention is in August 2015, this advertisement was issued. In July, my caste has been changed. And the last date for filling of the form is just 1 month from August 2015. Within a period of 1 month, an incumbent is required to get a new certificate. And he is not even he is belonging to a reserved category, BC1, financially weaker. And he is expected to get all the certificate within this period of 1 month itself.
देखिए, counsel for the parties are present.
My lord, your lordship's query is answered in Annexure D, your lordship. Annexure D of my counter.
What is Annexure D?
My lord, that is the clarification of the state government.
What is it? Read it.
My lord, kindly take note of the dates, your lordship. Advertisement was issued in August 2015. Then your lordship is August 2015 advertisement was issued.
Yes.
Last date was 30th September 2015.
Yes.
And my lord, his caste was changed, your lordship. Caste Teddy was changed. Teddy was changed on July 2015. 23 साल. On 23/7/2015, the caste was changed.
Yes. So, and what is this clarification?
Clarification issued by the state government, your lordship, because at that point of time, your lordship, several selection process was going on, your lordship, and as such the state government has clarified. 17 नवंबर 2015 का है कुछ भी क्लैरिफिकेशन 27 अच्छा हाँ ऊपर है 27 नवंबर 2015 का है
अगर तिथि 23/7/2015 के बाद पड़ती हो तो उक्त जाति के व्यक्तियों
My lord,
को
important
अत्यंत-
is this, your lordship, subject your lordship's pleasure. If the advertisement would have been issued, your lordship, prior to 23/7/2015, and the last date was, your lordship, fixed, that is the meaning, your lordship, after 23/7/2015, then the certain candidates were required to provide an opportunity. My lord, in the present case, your lordship, admittedly, your lordship, the advertisement was issued after 1 month.
But this particular circular is just an internal circular.
My lord, that
So
was
you were-
gazetted, your lordship. That was
Advertised.
my lord, that was published, your lordship. Must be published by
Must be means what? It is just a letter.
thus later to the.
See, when you advertise, then you can't.
My lord, when we advertise, your lordship, the tally was under BC1.
That's right. Therefore, he produced BC1 category.
My
So
lord,
BC,
my
prior to that,
my
it
lord,
was
my lord,
BC.
your lordship, my lord, can you see? Annexure A.
We have heard you. You just file your written submissions. We'll decide.
Only your
Leadership
lordship
can also indicate.
annexure
There
A.
is one other fact, though it is not mentioned in my writ application. In the LPA order, your lordship, at paragraph 20, it seems that till 18/12/2015, December 2015,
Yes,
it
there were
mentioned-
changes being
there
made.
have been changes. It is
We have
apparent
noticed
from
that there were changes being
Exactly,
made.
exactly.
Even till December.
Exactly. It is apparent from the aforesaid circular dated 18/12/15, the category under which one or the other person belonging, that is BC1 or BC2, was amended even as late as on 18 December 2015, that is even after the last date of filling of the application form of advertisement, that is 15/10/2015. And taking note of that fact, the LPA was allowed.
My lord,
I'll give
LPA
a
fact
written
was
notice.
different, your lordship.
You see, your advertisement remained vague.
My lord, in this.
Suppose there can also be a situation that a person is under one BC1 or BC2 category on 31/3/2015, and subsequently the name that caste has been deleted. Then what will happen?
My lord, then that he caste has been deleted. That
Suppose
will not,
then whatever be the status as you have given in the advertisement, that has to be taken into consideration.
My lord, that is correct, your lordship. My lord, I am not disputing the terms and conditions
Okay,
of
you
the
file
LPA.
your submissions. I
My
have
lord,
heard you.
my lord.
Right.
Obliged.
Heard the learned counsel for the parties. The matter is directed to be posted on. Heard the learned counsel for the parties. Arguments has been concluded. The matter is directed to be posted on. February 13th, 23, only for the purposes of filing their written notes of argument.
Obliged.
You just file it and then I will
My
resolve
lord,
it. Or whatever I have to do.
my lord.
ये भी है, चलो। एक चीज और it is not in dispute that the vacancies have now been advertised. Wide advertisement number
17 of 2020.
17 of 2023
On
and
20th of December 2020.
on 20th of December 2023,
In which the last date itself is 20th of this month.
and the last date for filling the form is 20th of
20th or 21st of February.
is yet to expire.
Yes, yet to expire.
That's right.
From the daily list, heading for admission fixed cases, item 1 WPS 6324 of 2023.
Last application, it was for the counter affidavit.
Yesterday we saw the counter affidavit, but we could not find it. Your ladyship actually be posted after 1 week so that we can.
You have served the copy?
No ladyship.
You want to file it when?
Your ladyship tomorrow.
WPS number 6324 of 2023. Counsel for the parties are present. Counsel for the petitioner respondents submit that the counter affidavit is ready for filing by tomorrow.
Any date?
Rejoinder, if any, to the counter affidavit. Let the counter affidavit be filed by tomorrow. Rejoinder, if any, by. You can file the rejoinder by 13th.
Yes.
Sure. Okay, rejoinder by 13th, post on 21st February. Under the heading for admission.
Item 2 WPS.
The parties to file their short synopsis, list of dates, and the judgments they seek to rely. Next.
Under heading for admission, item 2 WPS 598 of 2023.
Yes.
Your letter, during pendency of the writ petition, punishment have been awarded to the petitioner, by which gratuity amount have been ordered to be forfeited, and 25% pension.
So punishment has been awarded. The present case has become infructuous. You file your fresh writ.
Lordship, no, as per the compliance of last order, if the order has been passed, Lordship.
आइए को प्रेयर अमेंड करने के लिए माय लॉर्ड हम
That is a separate thing altogether. The contours of the adjudication will be totally different.
ग्रेचुटी रोकने का पावर इनको नहीं था.
तो वो आप अपना fresh writ करिए.
माय लॉर्ड ग्रेचुटी
You
रोकने
see,
का
you
पावर
had
नहीं
made a
था.
prayer to conclude the departmental proceeding. That has been concluded. Now if you have
प्रेयर वही नहीं था माय लॉर्ड. ग्रेचुटी वाला भी प्रेयर.
no, you file a fresh writ. In this writ petition, you cannot agitate the order which has been passed during the pendency of this case.
माय लॉर्ड मेरा प्रेयर थोड़ा देख लिया जाए.
देख लीजिए आपका prayer. We have seen your prayer. Right? देखिए. You have filed amendment petition. आइए.
माय लॉर्ड मार्च 2018 में हम रिटायर किए 31 मार्च को. उस समय ग्रेचुटी रोकने का इनको कोई अधिकार नहीं था. मेरा ग्रेचुटी
We will
रोक दिया
decide it, but not in this writ petition, because the contours will be totally different. It will totally change the nature of the writ petition. Naturally. The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner submits that during the pendency of this writ petition, the departmental proceeding has been concluded and punishment has been imposed upon the petitioner, which includes forfeiture of gratuity to some extent. He submits that accordingly, a petition for amendment of the writ petition has been filed, being IA number 8930 of 2023. The learned counsel for the respondents have opposed the prayer and has submitted that the contours of adjudication in the prayer seeking amendment would be totally different, and the nature of the writ petition itself would change. The amendment may not be allowed. However, the petitioner may file a separate writ petition if so advised. After hearing the learned counsel for the parties and considering the main relief which has been prayed for in the writ petition, this court is of the considered view that the departmental proceeding having been concluded and final order having been passed, the prayer for amendment of the writ petition would change the very nature of this writ petition. Accordingly, the amendment, IA number such and such seeking amendment to the writ petition is rejected. The liberty is reserved with the petitioner to take steps in connection with his grievance of the punishment which has been passed by the respondents in the departmental proceeding. In view of the subsequent development, the prayer made in made in paragraph 1 within bracket A has become infructuous, and so far as other reliefs are concerned, on account of the order of punishment passed against the petitioner, no such relief can be granted to the petitioner at this stage. The other reliefs will certainly depend upon the outcome of the challenge to the order passed in the disciplinary proceedings. Accordingly, this writ petition is also disposed of as such.
Item 3, WPS 629 of 2023.
This petition. What is it?
Ladies, on the last occasion, there was a direction to issue a local residential certificate to the petitioner and also to file a affidavit with regards to the same motion. I have taken instruction, it will take 10 more days
Affidavit.
for filing of the affidavit.
The learned counsel for the parties are present. The learned counsel for the respondents prays for and is granted time till 16th of February 2023 to comply the order passed by this court on 30/11/2023. Post this case on 19th. Give your appearances.
Item 4, WPS 712 of 2023.
This petitioner.
The challenge of annexure 8, the punishment order.
Counter has been filed.
Not counter has been filed.
Do you want to file any rejoinder?
Will not the
But nahi. If you want to file rejoinder, you file.
will not alternative remedy is there. The will not the statutory appeal shall lie. But therefore will not it shall be lie before the will not the divisional commissioner. I may be permitted to with liberty to avail that.
The learned counsel for the parties are present. The learned counsel for the petitioner submits that. As per the counter affidavit, the petitioner, you have mentioned it in the counter?
No,
The learned counsel, order 30
Under
The learned counsel for the parties are present. The learned counsel for the respondent has submitted that the petitioner has efficacious alternative remedy of appeal before the divisional commissioner, and therefore the writ petition may be disposed of so that the petitioner may avail the alternative remedy. He also submits that disputed questions of facts are involved in the present case, right? Upon this, counsel for the petitioner submits that the writ petition be disposed of so that the petitioner may avail the alternative remedy. After hearing the counsel for the parties and considering the submissions made, this writ petition is disposed of, enabling the petitioner to avail the alternative remedy within a period of 15 days from today. Dismissal of this writ petition, disposed of, okay, na? That's it. Accordingly, this writ petition is disposed of. Prayer for February.
Item 5, WPS 901 of 2023.
Petitioner. What is the counter affidavit?
In counter, in prayer, they have stated that to adjust the amount shown in no due certificate matter. But in counter, we have stated that there is a due of 159,332 rupees matter. And in the presentation of the petition, they have stated that he has paid that amount, but he has not produced any evidence regarding that matter, like the bank receipt or the payment receipt matter. And then parasection, we have also stated so far as this retirement benefits are concerned, Malad, that will be considered by the place where he was posted last time.
But unless the no due certificate is given, the retirement benefits also cannot be given.
It's not, but in page.
Who is for the petitioner? The three persons. WPS number 901 of 2023. Nobody appears on behalf of the petitioner. The learned counsel for the respondents has submitted that the prayer of the petitioner is for grant of no due certificate. But as per the counter affidavit, an amount of rupees 1,59,332 is due to be paid by the petitioner. She submits that although the petitioner has been stating that the said amount has been paid, but no proof of the same has been filed in the present case. She submits that once the
For last pay certificate, there was a due money.
She has also submitted that this amount was shown due in the last pay certificate issued to the petitioner. Since the petitioner is absent, देखिए जरा नाम लगा कर. Pose this case tomorrow.
Item 6 WPS 904 of 2023.
Counsel for the parties are present. Time till 28th February 24 is granted to the petitioner to file a rejoinder to the counter affidavit. Pose this case on 5th of March 2024. The part under the 5th of March 2024. The parties to, are there a lot of facts involved?
Yeah, yes, Your Ladyship.
The parties to file list of dates, short synopsis of arguments and judgments which they are seeking to rely upon.
Asking for compassionate appointment and benefits. Benefits, every benefits have been paid, Your Ladyship. Compassionate appointment we cannot give provide her because matriculation is the
Minimum qualification.
Minimum qualification. She is a non-matric.
So you don't need any list of dates for that. Pose this case on 5th of March.
Item 8 WPS 977 of 2023. Item 7 WPS 942 of
Yes,
2023.
petitioner.
In this case, Your Lordship, in an earlier occasion, Your Lordship, 5/7/2003, Your Lordship, respondent was directed to file counter affidavit, Your Lordship.
Counter not filed?
No, only counter affidavit filed by the respondent number 5, Your Lordship. But dismissal order passed by the respondent number 384, Your Lordship. So, counter is required in this case, Your Lordship.
Your Ladyship, I pray for 3 weeks time to file complaint.
Counsel for the parties are present. Counsel for the respondents. Counsel for the petitioner. Counsel for the respondents has submitted that a counter affidavit has been filed on behalf of respondent number 5. But counter affidavit from other respondents is also required. She prays for 3 weeks time.
Any date may be.
Accordingly, time till 5th of March 24 is granted to the respondents to file the required counter affidavit. Rejoinder if any by 12th, post on 19th of March.
Item 8 WPS 977 of 2023.
Yes, petitioner.
These are the list of dates which we have.
What is the matter about?
But the matter is relating to my last, the compassionate appointment, and my case has been rejected by order under challenge at annexure 6. Which
What
is
is the
at,
ground for
they
rejection?
said that I am above 35 years of age, my lords. Medical board was constituted and they decided that at the time of application my age is 36 years, 4 months, 22 days. 22 days.
What is the date of death?
Well, the date of death is, my lord, 9/12/2021.
Okay. When did you file the application?
I filed my application on 25/2/2022.
Within time? It was within time?
Within time.
What is your age according to you? Are you non-matriculate?
Yes, my lord.
Non-matriculate?
Yes, I am non-matriculate.
You are totally illiterate?
No, my lord.
What is your qualification?
My lords, I have passed, my lords. But I have annexed.
You have not gone through a brief?
No, my lord.
When you say no, it means that you have not gone through.
Yes, sir. I have passed 6th class, my lord.
6th class.
6th class.
What is your proof? What is the proof available with you with regard to date of birth? According to you, what is your date of birth?
My date of birth is, my lord, 1/7/1989.
1/7/1989. What is the basis?
But there is Aadhaar card, my lord, which has been issued on 31/12/2022. 12, my lord. I'm sorry.
31?
31/12/2012.
2012.
Yes.
Where is that?
Annexure 7, page 27. Then the driving license.
Your name must be there in their records also.
Ma'am,
May I be allowed to clarify? In this, actually, the precondition in the NCWA is that he cannot be above 35 years of age. So the medical, since he was a non-matriculate, so medical board was constituted and he was found to be above 35 years of age, and on basis of the service records that were available.
What is the date of examination?
Date of
examination. It's 28/7/2022.
28/7.
Medical board.
I have annexed the letter of the medical board. Age assessment of the petitioner was done before the medical board, dated 26/7/2022.
That is the letter.
That is the letter that he was non-matriculate and therefore the assessment should be done. Thereafter, based on the various documents that were submitted and the service records of the deceased employee, he was shown to be above 35 years of age, and as per the medical board assessment committee also, he was above 35 years of age. And in fact, in several judgments, this has been held consistently that 35 years and above, if that is the precondition, if he has not qualified that, then he cannot be given compassion.
Did he produce this Aadhaar card?
Not at that time. Not at that time.
Did you produce Aadhaar card and your birth certificate before the authority, or you are producing it here for the
He's
first time?
producing it here in the writ court
No,
for the
no,
first time.
no.
There's been no appeal. As per my instructions, there's been no appeal. And in fact, in one LP also that was filed.
Let me place my case. Otherwise, I'll sit down. My lord, may kindly have annexure 3.
What is the point you want to put
My
across?
lords, this is a settled principle, my lords. There is the judgment which has been held, my lords, that once it is a case of 35 to 40 years, then, my lords, if the lower range has to be taken into consideration, while consideration, my lords.
They have given you 35 to 40 years.
No, they have given 36 years, my lords. And
They have not given the range.
Well, they have not given the range because
They have
was-
given exact age.
No, I have given the statement that as per practice they have given 35 to 40 years, my lords.
No,
and they have not
where is
re-
that medical assessment?
They have not annexed that, my lords. But I have stated at para
They have
14.
not annexed means, where is that document? Yes, madam? Where is the document of medical assessment?
I'll just check.
I have stated that at para 13 and 14. my lords. 14 I have stated, my lords. The adverse is given to the petitioner and practice
Where is the
adopted.
document?
I'm just checking.
They have not annexed it in the counter
We have not
affidavit.
annexed it. We'll bring it on record, my lady. I'll if required leadership, I'll bring it on record. But leadership
Learned
can-
counsel for the parties are present. The counsel for the petitioner submits that although a counter affidavit has been filed in the present case, but the examination by the medical board has not been placed on record. The counsel has submitted that as per Aadhaar card issued to the petitioner, the date of birth has been recorded as
1/7/1989.
1/7/1989.
1989.
1/7/1989. The learned counsel for the respondents has submitted that the Aadhaar card was never relied upon by the petitioner before the authority. He has relied upon the same for the first time in the writ petition. She has also submitted that the date of birth in Aadhaar card is primarily recorded on the basis of self-declaration, and the same cannot be said to be a conclusive proof of the date of birth. She has submitted that during the medical assessment, the age of the petitioner was found to be 37 years as on 28/7/2022, and therefore the petitioner is not entitled for compassionate appointment. Even on the date of death, he would be over age. Counsel for the respondents is directed to produce the records of this case. Whatever documents is there,
representation says otherwise, my lords, that I have produced.
आने दीजिए ना record. जो
हाँ,
आपने दिया है वही जानते हैं. जो होगा वो वहाँ पर होगा. As simple as that. New document you cannot rely upon before this motion.
नहीं, otherwise हम representation भी दिखा रहे हैं, which they have admitted that it is a representation.
We will see. We do not know.
And it is not leadership in the LPA also. It was held
When
that
will you produce?
in the High Court it is not in a writ proceeding. They cannot open cannot change the policy.
Judgments, if I may be allowed.
When will you produce it?
Leadership 2 weeks at least.
Okay. Pose this case on 27th February.
27.
Right?
Leadership, I will immediately communicate with them.
27th February.
May I also give forth some judgments?
You just put your name that you are relying on that.
Item 9, WPS 1024 of 2023.
Who is for the petitioner? Counter affidavit filed?
No, sir. Fine.
Where is the petitioner? What is your stand in the counter affidavit?
Lordship, in my counter affidavit, annexure E.
You
Decision
just tell us straight away. Decision has been taken.
Lordship, annexure E में द्वितीय ACP को दिया गया है with effect from 28/1/2016.
Yes.
Serial number 36 पे इनका नाम शो कर रहा है.
That's right. But she wants it from the appropriate date, no?
Lordship, first ACP को मिला है Lordship 2001 में.
2001.
Lordship.
Then why there is a delay of so many years? This is second ACP, right?
Lordship, first ACP को दिया गया with effect from 3/8/2001. द्वितीय को दिया गया Lordship 2016 में.
But this first is not mentioned in her name at page number 45 of your counter affidavit. First ACP has been shown as blank.
ये लॉर्डशिप एनेक्सर डी में इनका नाम है, पेज नंबर 14 में, सीरियल नंबर 12 में, बैड रिजोल्यूशन मेमो नंबर 574 डेटेड 28 अगस्त 2000।
Annexure D, serial page number?
पेज नंबर लॉर्डशिप 41, 40 से स्टार्ट है डी में, पेज नंबर 41 में इनका नाम, सीरियल नंबर 12 पे। ये पहला एसीपी दिया गया था सो।
So why have you not, when did she become entitled to second ACP? She is claiming from which date? 1/9/2009. Why have you not given her the second ACP from 1/9/2009?
It has not been stated in the counter affidavit.
There was a specific order. You don't even read the order at the time of filing counter affidavit. There is an order dated 18th April 2023 giving the entire case of the petitioner. इससे ज़्यादा हम लोग आप लोग के लिए नहीं कर सकते स्टेट के लिए. We can't do more than this. By calling for the counter affidavit, a proper order has been passed to enable you to file a proper counter affidavit. So, what is your explanation for not granting the benefit from 1/9/2009? Counsel for the petitioner is absent. Counsel for the respondents submits that he shall seek instructions and file supplementary counter affidavit by addressing the concern of the petitioner as raised in order dated 18th April 2023. Let the supplementary counter affidavit be filed by 28th of February. 27th February, post on 28th. File करिए अपना supplementary counter.
Item 10 WPS 1628 of 2023.
Yes, petitioner.
The petitioner has appeared in the Home Guard, has applied for the appointment of the Home Guard matter. He has passed in physical and the written test matter. It will appear from the Annexure 4 matter. Annexure 3, 22 at page number 30 matter.
Yes, page number 30.
Matter 22 candidates have been selected. And the petitioner's name appears at serial number 11.
Benito Kumari.
But out of 22, 18 candidates have been selected, that is at Annexure 4. 1131, just 31. The Lordship will find that only this list manner, the person, 3 persons were appointed, constituted a appointing committee manner. 3 officers were there, but only 1 officer has signed. Jila Samadeshta Jharkhand Shawahini. 2 officers have not signed. They have not assigned the reason as to why those candidates who were at serial number 11 and having more marks than the others have been rejected. This is my case. But
You were having more marks than the selected candidate?
my lord,
From where do you say?
Yes. My lord, para 19, my lord.
Para.
May I read
How
para
much
19?
how much was your marks and how much was the marks of the selected?
3 candidates have the equal marks, madam.
Which 3 candidates?
3 candidates have the equal marks, including these petitioners.
Your name, your marks? How much? Where have you stated?
Yes, I have studied, madam. Well, for a moment, I have find the chart, my lord, where the marks indicates, my lord. That in my rejoinder, my lord. Marks chart, my lord, I find the marks chart. I will showing it from here, my lord.
You tell us that who is the selected candidate who had equal marks as compared
My
to
lord,
you? Give the name.
my lord, para 18 candidates, this is at page number 39, my lord. These 18 candidates have been selected.
It is already there.
Huh?
So,
Para 9, I am reading para 9, that will show that I have the more marks than others. But there are some candidates who have.
Show us that you have more marks. Where have you stated?
Para 9 Patna Huzur of my read petition. That the petitioner humbly states that the total seat in Devghar district is 44, and in Madhupur block the total seat is 37. But out of 37, 18 Mahila home guards were shortlisted for finalists.
Out of shortlisted candidates, why have you selected only 18?
Yes, Your
How many
Ladyship,
posts was advertised?
Yes, Your Ladyship, there was in the district of Devghar, there were enrollment of home guards for the total seat of 644.
644, yes.
Yes, Your Ladyship. And in the district of 644, according to its requirement, there were 37 seats vacancy in the Madhupur block. She has
That's
applied
right.
for that. And there will be, it has been mentioned that 50% seats will be for female and 50% for the male. 50% male ho gaya, that is 19. That is annexed, that has already been written in Your Ladyship. And 18 and a half to nahi hoga, that's why 18 and annexure 4 that the petitioner has already annexed, Your Ladyship. That I'll clarify in paragraph 11 of my counter affidavit, that annexure 3 of the writ which he is mentioning 9/2/2023 was the list of the successful candidates who has passed the physical and the written test.
That's right, that is not a gradation list.
Yes, Your Ladyship.
So that's
Annexure
okay, that
4
we
is
understand.
the Annexure 4 is the final list, Your Ladyship.
Yes, that's fine. So those people have
Who has
got more
qualified?
marks. More marks.
More
than-
marks.
What
I
is
have
the
already-
marks of the petitioner
I
and what is
have
the marks of the selected candidate?
Page
Last
14,
selected candidate.
Page 14 of my counter affidavit, Your Ladyship. It will be pertinent to mention that the merit list of the enrollment of home guard was prepared according to the basis of marks and date of birth. And the cutoff for the female candidates for Madhupur block was 21 and cutoff date of birth was 1991. While the petitioner has obtained 21, but the date of birth is 1997. And she could not find the place in the merit list.
Rightly so. You see, if there
According
is
to
a
the
tie,
rule
if there is a
2014
tie, the person who has more age will be given preference. Right?
And annexure 4 में ये फायदा लिखा ही हुआ है, which he is mentioning page 31. उपरोक्त अंकित अंतिम रूप से चयनित महिला पुरुष अभ्यर्थी का परीक्षा फल इस शर्त के साथ प्रकाशित किया जा रहा है कि चिकित्सा जांच पुलिस सत्यापन के दौरान किसी महिला अभ्यर्थी के आयु के पाए जाने की स्थिति में संबंधित, and 3 of them have already.
No. I have found the rejoinder. For a moment, it may be seen at page number 90.
Page number?
90.
Yes. Is it correct that you had same marks as the last selected candidate?
I am showing from here, madam.
It is correct or incorrect?
Yes, correct. हुजूर यहाँ से देखा जाए, जिसमें I have raised two issues, madam. That I have more marks than the some few candidates who were selected. This is my first point.
Which candidate? Name, give the name.
Madam,
They say that the last selected candidate had the same marks as yours.
Madam, I am saying so, madam. एक बार पेज नंबर 19 दिखा दें.
आप रिजॉइंडर का ना स्टेटमेंट बताइए, हम एनेक्शर से केस बहस नहीं करना. आप बताइए कहाँ डिनाई किए हैं स्टेटमेंट को.
वो भी दिखा दें.
Show me that only. Annexures say the practice of argument from the annexures is not.
good. Para 8 पढ़ रहे हैं rejoinder.
Yes.
That with regard to the statement made in para 8 of the counter affidavit is not correct.
the answering document has given the wrong information to the court because the out of 644 seats, only 280 candidates were appointed. Among them, 190 is male and 90 is female. Though they have disclosed that 50% seat.
No, they are considering Madhupur block. For Madhupur block, they had 37. Out of that, they had taken 50%, 18 for
18
for
female
female and 19 for male. And amongst the selected candidate, the last person got 21, who is of
3 persons got.
but the person who had the maximum age has been selected.
One thing. Second thing,
That is the only thing.
reservation roster has not been obeyed by them. This was my plea, my lord. That is what I am showing from there. If the lordship will see.
Where have you stated that the reservation roster has not been followed?
Yes.
Show me your statement, then I will see that.
My lord.
Where have you stated that the reservation roster has not been followed? Tell us. No such statement. No such statement. We will not. हाँ बताइए. कहाँ पर है बताइए.
दिखा.
Show me from the writ petition.
एक बार इसको.
Show me from the writ petition. I will not adjourn the case. I am hearing it for 15 minutes now. You just show me from the writ petition that your case was.
दिखा रहा हूँ. ये law भी formulate हम किए हुए.
Where is your statement in the writ petition? No such statement has been made. So that is not your demands. Don't argue beyond the records. And you belong to which category?
SC. SC.
Has the reservation roster been followed?
Yes, Your Ladyship, and enrollment of the processes also has been done here. So,
my lord, ये पेज नंबर 18 का मेरा इशू पॉइंट देखा जाए कि whether reservation roster is followed by the respondent authorities while publishing the final stated so and so. I made this statement, my lord.
This is the question you have raised.
हाँ, क्वेश्चन रेज किए मुझे. इसका स्टेटमेंट भी है.
Have you responded to this?
उसका स्टेटमेंट भी है.
Statement to I haven't seen.
Page number 8. Question number K. No SC candidate has been inducted?
Only one, perhaps only one selected, my lord. That is why, for this purpose, I am showing the list, marks and age. That is at my rejoinder.
Your Ladyship, if you see annexure 4, किसको पॉलिना किसको ममता कुमारी
हुजूर एक चीज हुजूर पेज नंबर 19 पे देखा जाए हुजूर वही मैं दिखा दे रहा हूँ. इसमें ज्यादातर जितने हैं ज्यादातर लोग केवल यादव लोग सेलेक्ट हो गए. ये मैं दिखा रहा हूँ कि रिजर्वेशन रोस्टर वो नाम में है जो मैं ऐसा नहीं बोलता वो लिखा हुआ है वहीं से. हाँ उसमें सभी का मार्क्स दिया हुआ है सभी का एज दिया हुआ है.
You just talk about your female candidates.
हाँ
where is the list of female candidates?
फीमेल कैंडिडेट का फीमेल का ही है उसमें जो
पेज
नंबर 19. हाँ मधुपुर महिला की रिक्त 80 उसमें केवल देखा जाए हुजूर.
मधुपुर महिला
हुजूर को मिला नीचे वाला पार्ट में हुजूर.
नहीं उसमें मधुपुर तो कहीं नहीं दिख रहा है. शहरी तकनीकी
बीच में लिखा हुआ प्रखंड मधुपुर महिला की रिक्त 18 हुजूर. ये पेज है
नहीं ये आपका
ये रिजॉइंडर का हुजूर.
रिजॉइंडर का आपका पेज नंबर टैली नहीं कर रहा है.
नहीं सारवा सोना रहे
मधुपुर
तो नहीं है.
It is at page number 17.
17.
Yes. प्रखंड मधुपुर महिला की रिक्त बताइए.
हाँ वो उसमें केवल महिला का हुजूर. मैं ये दिखा रहा हूँ.
बताइए. So many candidates got the same marks, 21.
21 यहाँ 4 कैंडिडेट्स का है जो इनमें से कुछ एज है जिससे हमारा ज्यादा है वो हम लिख रखे हैं
4 से भी ज्यादा है 4, 5, 6, 7 नेक्स्ट पेज में
उससे हमारा ज्यादा है और 20 नंबर है तो मेरा भी तो सिलेक्शन उसमें होना चाहिए था जो
नो
डेट ऑफ बर्थ के
डेट ऑफ बर्थ के हिसाब से होगा there are 7 candidates with 21 marks.
Yes, your ladyship, 21 marks इसीलिए डेट ऑफ बर्थ भी उसको रखा है.
That's right. You file an affidavit to which category these people belong and as per the road whether the reservation roster has been followed.
पारा 11 में हम हुजूर उसका स्टेटमेंट भी दिए हैं
क्या इसी का पैरा 11 में
हाँ रिजॉइंडर के पारा 11 में
yes
एक बार पढ़ते हैं हुजूर that with regard to the statement made in para 12 of the counter affidavit it is totally incorrect because swearing respondent has not replied the issue. Respondent number 3, 4, 5 were the members of the appointment committee, then 2 senior officials, respondent number 3 and 4 dated so and so have not signed swearing it contrary to the law and it is admitted by the swearing respondent despite the fact that seats are vacant. The marking of the physical test is highly objectionable because Lisa Kumari roll number 5, Annu Kumari roll number 6 having equal marks and
the
under
learned
age
counsel for the parties are present. The learned counsel for the respondents by testifying the selection of other candidate who had secured 21 marks has submitted that whenever there is a tie in marks, the candidate having higher age
that would be given preference.
Will be given preference as per the policy of the state.
Indeed.
However, the petitioner has also raised a grievance in the petition that the reservation roster has not been followed. This aspect of the matter has not been addressed by the respondents in their counter affidavit. The merit list produced by the petitioner in the rejoinder also does not disclose the caste status of the selected candidates. Counsel for the respondents is directed to seek instructions and file a specific affidavit in connection with the plea raised by the petitioner regarding reservation roster. The petitioner claims to be belonging to scheduled caste category. How much time do you need?
3 weeks here.
The supplementary counter affidavit be filed by 29th of February. Rejoinder, if any, by 5th of March. Post this case on 13th of March.
Item 11 WPS 1998 of 2023.
Who is for the petitioner?
Yes. The present petitioner was working as a sub-inspector of police. Subsequent to that, by a charge sheet, a disciplinary proceeding was started, and thereafter finding him guilty, punishment has been imposed upon him. To that we filed an appeal that was also dismissed as being time barred. And because of this, the ACP that was to be granted to him in the year 2006, that has been granted in the, after 9 years, that is in the year 2015. For these 3 reliefs, we have come to this honorable floor. Please just have a look to Annexure 1 at page 29. This is the order.
I will require the sequence of dates.
Only 3
dates are important.
No, Your Lordship. Final order was passed in the year 2007, and then they approved the appellate authority in 2015. That is.
That's right.
2022.
You entertained the appeal, no?
Yes, Your Lordship. Yes, very. On the ground of limitation.
On the ground of limitation.
That was dismissed.
And then they closed that, Your Lordship. On the court.
What is the ground for delay?
The
It has been
ground for
dismissed on
delay-
account of delay.
The ground for delay they have explained. Your Lordship, may please just have a look
Who
to
has explained?
the persons themselves, the respondents. from the year 2007. Please just have a look to the counter affidavit at page number 12. That it is stated that the entire original record of the proceeding aforesaid got destroyed as per the report submitted by the officer of the police line Chaibasa through memo number such and such. Para 13, that it is stated that there were some wrong entries made in the service book of the petitioner earlier.
Naturally, you see, these records were destroyed because no appeal was filed.
No, they did not give the order whereby...
When did you get the order for the first time?
In November 22, when I looked into my service record, I saw that I got my ACP after a delay of 9 years.
So you must have explained the delay before the appellate authority.
Yes, yes. And that because of the fact...
Just a moment. Where is the appellate, where is your memo of appeal?
Memo of appeal we have not. Please just have a look to the memo of appeal.
Where is the memo? Once the records are destroyed, how will the appellate authority appreciate your case? Where is your memo of appeal?
This is annexed 2.
There is no explanation. There is no explanation for delay. Where is the appellate order?
Next page, Lordship, page number 33.
Anything else you want to submit, Mr.
Yes. Your Lordship, may please just have a look to page 29, annexure 1. The order passed by the disciplinary authority.
No, we cannot enter into the order passed by the disciplinary authority because the appellate authority has rejected your case on ground of delay. And further, as per the counter affidavit, the records are also not available.
The records were not available. The order of the...
Because they have been destroyed. Because you never challenged the order.
The order of the disciplinary authority was never given to me.
So where do you say, even before the appellate authority,
In the rejoinder, Your Lordship, may please...
In rejoinder, no. Before the appellate authority, you never said. In rejoinder, you are making a statement that was never given. Can't be like this.
My humble submission before Your Lordship is that if the order of the disciplinary authority itself is completely wrong, that will be depicted from the order itself. And if in the inquiry officer, conducting officer, has said that all the charges that have been levelled as against me are not found to be correct.
Where is the inquiry report?
Your Lordship, may please just have a look to annexure 1. Everything has been discussed, and they have stated in their counter also, at paragraph 10.
Yes.
That is at page 29, the last paragraph. जांच पदाधिकारी ने अपने मंतव्य में उल्लेख किया है कि आरोपित के विरुद्ध गठित आरोप, प्रदर्शनों के अवलोकन, साक्षी के बयान एवं बचाव स्पष्टीकरण से आरोप प्रमाणित नहीं होता है। चूंकि आरोपित के विरुद्ध आरोप की गिरिगुरु थाना, thereafter he goes to say about the charge that was levelled as against me. inquiry officer did not
What was
find,
the charge against you?
I did not submit the case diary, Your Lordship, within the proper time. That was the only charge. And that was not found to be correct by the inquiry officer. Then law requires, Your Lordship, if the disciplinary authority differs and disagrees with the finding of the inquiry officer, then a show cause has to be given with the finding that on these points I differ with the inquiry report. So you please submit your show cause what you have to say, because I will carry on giving the order. That was never done. It is in the order itself. And subsequently he proceeded. And thereafter, Your Lordship, he found me guilty and he awarded the punishment. And this order of punishment was also never communicated to me. Only in the month of October 22, when I looked into the service records, Your Lordship, I came to know that this order has been passed as against me. We filed a appeal that was rejected on the ground that it is filed after 15 years. And then we have come to this honorable court. The disciplinary authority himself has assumed the role of the inquiry officer, and without taking into consideration that after holding an inquiry, the inquiry officer has not found any allegation which has been leveled as against me to be true. Without giving me any opportunity to explain, he has proceeded, Your Lordship, and inflicted the punishment. And total non-application of mine in inflicting these punishments, Your Lordship, will be depicted from the counter affidavit filed by the respondent themselves. And that was entered into the service records. And only thereafter I came to know what has happened with my case. I have categorically stated, Your Lordship, that the order was not supplied to me. As
See,
such,
the whole point is that if there is a violation of principles of natural justice at various stages of the disciplinary proceedings, the matter is remanded to the authority from the state stage, right? If the disciplinary authority wanted to differ with the findings of the inquiry officer, he should have given you a show cause and then he should have proceeded. According to you, there is a procedural lapse so far as this aspect of the matter is concerned, right? Now, since you did not file your appeal for years together,
I was not knowing about that.
from where do you
Yes,
say?
Your
You
Lordship,
have not
please
even
see.
stated so before the appellate authority that
Your
you
Lordship,
had
may
no
please-
knowledge
Paragraph 17, Your Lordship, may please see, of my application,
writ application.
of my writ application.
Are you not supposed to explain the delay before the appellate authority?
Look, before the appellate authority also, if I have not been able to explain, Your Lordship, even then, equity requires what is the charge and what is the punishment and what is the consequence of the punishment for an
What
officer.
punishment was imposed on you?
Yes, Your Lordship, that is there. Your Lordship will please see. Inflicted the punishment of 1 black mark upon the petitioner, punishment of non-grant of increments for next 6 months, which would not have the effect on his future service. But in the service record, Your Lordship, it was mentioned that throughout his service career, this non-grant of increment would carry on. And after coming to know in the service book of petitioner, punishment incorporated was withholding of increment for 6 months, which will affect throughout his service career. And in spite of memo of appeal being filed, Your Lordship, it was time barred.
You had participated in the disciplinary proceedings?
Yes, Your Lordship.
And you say that the order of the disciplinary proceedings was never communicated to you?
No, never.
Where have you stated?
In paragraph 17, Your Lordship.
Can you read it?
Your Lordship, may please see.
Yes. Kindly read it. Yes.
Your Lordship, may please allow me what I have stated. Paragraph 14, Your Lordship.
You wanted to play 17.
Prior to that, 14, Your Lordship, please. That neither was the punishment matter imposed by the disciplinary authority, that is Superintendent of Police Chaibasa, was known to him, but the petitioner was shocked and surprised to have come to know that although the punishment imposed upon him was for 6 months, withholding of increment, having no effect on his future service career, but in the service book of the petitioner it was categorically inscribed that this punishment of 6 months withholding his increment shall have effect throughout his service career, and as such the same is still in vogue as against the petitioner. The order of punishment was not given to him. Subsequent to that, when he came to know that an order has been passed, he looked into the service record, Your Lordship. Thereafter, he came to know in the month of October 2022 that this punishment is throughout his service career. And what they have stated in their counter affidavit, Your Lordship, will please see that
was rectified, Your Lordship.
that shows a total non-application of mind in view of the fact, Your Lordship, will please see. Punishment imposed another Rajesh Kumar, Your Lordship, was incorporated in my service book. And all the records at Chaibasa were missing, Your Lordship. The matter was finally known in the year 2015. Thereafter, they have prepared, and in the year 2022, Your Lordship, everything has been said to be right. And I have filed my appeal in the year November 22 itself, after coming to know that a punishment order has been passed as against me by the disciplinary authority. For that, Your Lordship, the ACP which was due to be given to me in the year 2006, that has finally been given to me in the year 2015. There is a delay of 9 years, only because of all this. And the charges which were levelled, Your Lordship, that was never found to be true. The inquiry officer has categorically stated, the inquiry report has not been given to me. Show cause was never given to me to explain.
You just see the order of punishment, that is at annexure number?
Annexure 1, page 29. The relevant portion starts in the last paragraph and subsequently at page 30, Your Lordship.
You just see page number 30. What is this? तदोपरांत निर्गत प्रतिवेदन 5 दिनांक 21/9/2005 के माध्यम से किरगुरु के अनुशंसा के आलोक में आरोपित से के विरुद्ध स्पष्टीकरण की मांग की
गई है.
हाँ.
That is प्रतिवेदन 5. That is about the case diary. That is about the case diary, not about the inquiry. There are several stages in the case diary, Your Lordship. PR1, PR2, PR3, PR4, PR5.
What is the date of the submission of inquiry report?
Inquiry report, Your Lordship, is
Dated?
they have not given me the inquiry report at any point of time. पेज 30, Your Lordship, मैंने भी इस विभागीय जांच संचिका में संलग्न आरोप प्रदर्शों, साक्षी के बयान, आरोपित का बयान स्पष्टीकरण एवं संचालन पदाधिकारी के मंतव्य का गहन अवलोकन एवं समीक्षा की। मैं समीक्षा उपरांत संचालन पदाधिकारी के मंतव्य से असहमत हूँ। मैंने आरोपित के विरुद्ध लगाए गए आरोप का अवलोकन किया and thereby your lordship finding it to be correct, he has imposed the punishment. Neither he gave me an opportunity to explain, neither he gave me the copy of the inquiry report, why he disagreed with the findings of the inquiry officer, that show cause was also not given, and finally, your lordship, he took the charge of the inquiry officer, finding the charges all to be correct as against me and imposed the punishment. And the copy was also not given to me.
Explanation was not regarding the case diary, lordship, regarding the conduct of the petitioner, my lord.
What is the date of the inquiry report? And what is paragraph Roman 2 at page number 15 of
Yes,
your
Your
counter affidavit? What is it?
Is that, your lordship, there was some error and it was rectified later on.
What rectified? What was the error?
Effect of the punishment given.
What was the error?
Yes, your lordship, I'm doing the same thing.
First tell us that what was the error and then we will see the effect of the punishment.
That there would not be any effect of the punishment punishment of increment holding of the petitioner for 6 months in future pay increment.
What
Was
does
removed
that?
at all.
What was the punishment imposed?
Punishment imposed, lordship was.
छह माह की वेतन वृद्धि पर रोक लगाई जाती है, जिसका मान 1 कालांक के बराबर होगा तथा इसका भविष्य में नहीं पड़ेगा. Right? So, what is the rectification you have done?
As per the counter
So the rectification was done, your lordship, of the punishment which was imposed in another district departmental proceeding number 83 of 2004.
You were subjected to another disciplinary
Yes, your
proceeding
lordship.
also.
No, because of my name, another person, your lordship, Rajesh, posted at Gaya, against whom also there was a departmental proceeding, and his punishment was also incorporated in my service. That your lordship will please see paragraph page number 14 of their counter affidavit, paragraph 13. That is why I say that total non-application of mine, because the records were also not there, no papers were there, your lordship, in a hurried manner, everything has been done. Page number 14, paragraph 13. And at paragraph 10 of the counter affidavit, your lordship, they have also stated.
You see, the records are, yes.
Kindly see page number 26 of the counter affidavit, my lord.
26.
Yes, your lordship. This is Chaibasa Jiladesh Shanghya 867 of 23. Here it has come the rectification, the last paragraph. अतः समीक्षोपरांत चाईबासा जिला विभागीय जांच संख्या 8/2006 के आलोक में चाईबासा जिला बल के तत्कालीन पुअनी राजेश कुमार सिंह वर्तमान पुलिस विशेष शाखा झारखंड रांची की सेवा पुस्तिका में अंकित 6 माह के वेतन वृद्धि पर रोक जिसका प्रभाव भविष्य के वेतन वृद्धि पर पड़ेगा को सुधार करते हुए 6 माह के वेतन वृद्धि पर रोक जिसका प्रभाव भविष्य के वेतन वृद्धि पर नहीं पड़ेगा. That only future implication will not be there, lordship. That was there, punishment was there of 6 months. So this was the rectification.
You have annexed a copy of the inquiry report, or the entire records have been destroyed?
Has been destroyed.
When was it destroyed?
Yes, sir. Kindly see page number 23 of my counter, madam.
Yes.
Not just that of petitioner, but other persons also. Second paragraph. चाईबासा जिला का वर्ष 2006 का दिमाग द्वारा अनुसूचित किया गया संचिका की सूची विभागीय जांच प्रारंभ संचिका 18 कुल उपलब्ध संचिका 2 कुल नष्ट संचिका 16 and the name of the petitioner is finds serial number 7 to Rajesh Kumar. 2007 itself it was destroyed.
2007.
7.
So you
Petitioner
destroyed the records in 2007.
Original documents.
Original documents, you
Statement
destroyed the records in 2007 in a disciplinary proceedings where the punishment was imposed in 2007.
What you say, Your Worship?
दीमक नष्ट कर देता है, record कौन रखेगा? In 2007, the termite has eaten up all the records. Who will be responsible for this? Yes? Who will be responsible for this? And the punishment was such a punishment that he may not have even noticed that any punishment has been passed. You see, the matter has to go to the appellate authority. He will have to be given an opportunity to explain the delay, right? The years of delay is not important. Important is the explanation. And if you are able to dig out any material from your entire record that he had this information, maybe that he was denied promotion on account of punishment, quite possible, you confront him with that. And then his statement that he had no knowledge about it because it's quite a long time. Maybe that his promotion is denied, or maybe some kind of benefit is denied to him, or ACP is denied to him on this ground. Then that can be a ground to reject his petition for condonation of delay. Once an appeal is filed, in this High Court also, appeals are filed without Section 5 petition. Does the registry throw it into the dustbin?
No.
Opportunity is given to the parties to file a petition for condonation of delay. It is a condonable delay. You can't just throw anybody's appeal, and on the face of it, it appears that he was not, the inquiry officer had filed a report in his favor, and subsequently there was no show cause was given to him to differ from the findings, and straight away the disciplinary authority has passed on to him. Is that correct? Learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that on the face of the impugned order passed by the disciplinary authority, the inquiry officer has given findings in favor of the petitioner, and the petitioner was not found guilty. But there is no mention of any communication to the petitioner before the disciplinary authority differed with the finding of the inquiry officer and imposed the punishment. The learned counsel submits that on the face of Annexure 1, there is no mention of second show cause having been issued to the petitioner. The petitioner was imposed the punishment of stoppage of 6 monthly installments with non-cumulative effect. Right?
Yes, sir.
The learned counsel submits that the petition, since the such punishment was equivalent to 1 black mark. The learned counsel submits that since the punishment was of such a nature, although the petitioner participated in the disciplinary proceedings as is apparent from Annexure 1, but the order of punishment was never communicated to the petitioner. He submits that the fact that the petitioner did not know about the order of punishment has been mentioned in the writ petition. The learned counsel submits that subsequently an appeal was filed by the petitioner before the appellate authority on
your lordship, November 22.
On November 2022, and the appeal has been dismissed on the ground of limitation. The learned counsel submits that the appellate authority ought to have given some opportunity to the petitioner to explain the delay, but no such opportunity was given, and straightaway the appellate authority has dismissed the appeal on technical ground. The learned counsel has further submitted that as per the counter affidavit, the records have been shown to have been destroyed as back as in the year 2007 on account of termite, and in the counter affidavit the respondents have themselves stated that there was certain wrong entry in the service book of the petitioner regarding the punishment imposed, and the same has been rectified by order dated 6/6/2023. The Learned Counsel submits that, considering the fact that the punishment has serious impact upon the petitioner, the appellate authority, the matter may be remitted to the appellate authority and the petitioner may explain his delay in filing the appeal. The Learned Counsel has also submitted that if there is any material with the respondents to show that the petitioner had any knowledge of the order passed in the disciplinary proceedings, the petitioner can be confronted with the same. That's it.
Yes, Your Honor.
The Learned Counsel for the respondents, while opposing the prayer of the petitioner, has submitted that the petitioner should have explained the delay in the memo of appeal also. The delay was for a period of around
15 years.
15 years. The fact remains that the records were destroyed by termites way back in the year 2007 itself.
6, Your Lordship. Yes, 2006.
2007 they have mentioned.
Your Lordship will please see.
At the bottom of this, Your Lordship.
No,
2007.
Please just come to page number 23. चाईबासा जिला का वर्ष 2006 का दीमक द्वारा नष्ट किया गया। 2006 and my name finds that
नहीं 2006 7
7
sorry उसको 2007 नहीं 2006 was destroyed in the year 2006 itself. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, this court is of the considered view that the appellate authority ought to have given an opportunity to the petitioner to explain the delay in filing the appeal. Still, such opportunity can be granted, and certainly it will be open to the respondents to refer to one or the other document or one or the other event which would reflect that the petitioner had knowledge about the order of punishment passed against him, so as to disentitle him for condonation of delay and to challenge the order of the disciplinary proceedings after a considerable length of time.
Knowledge before 2022, my lords. Any day
वो तो
before.
सारा limitation तो knowledge before 2022. He will explain his date of knowledge. In view of the aforesaid facts and circumstances, and after considering the order of punishment itself, this court, in view of the aforesaid facts and circumstances, the impugned order passed by the appellate authority is hereby set aside. The appellate record, the records of the appellate authority is restored to its original file, and liberty is given to the petitioner to explain the delay in filing the appeal by filing appropriate application before the appellate authority within a period of 15 days from today. if such an application is filed, appropriate order be passed by the appellate authority on the petition for condonation of delay after seeking verification from the authorities at Chaibasa or in the department as to which could demonstrate that the petitioner had knowledge about the passing of the order passed by the disciplinary authority. The appellate authority shall pass appropriate orders in the petition for condonation of delay and appropriate reasoned order, and if the delay is condoned, then appropriate order be passed by the appellate authority on the basis of the materials which may be available on record. क्या ऑर्डर पास करेगा?
I will file a fresh appeal along with the delay condonation, Your Lordship. That firstly, the delay condonation application will be heard, decided. If the delay is condoned, then the order passed by the disciplinary authority will be considered.
Will be considered on the basis of materials available. The petitioner would also produce a copy of the entire records of the petition. That's it.
And that may be treated, that may be served upon.
You whatever you have to explain, file a copy of the records also. This petition is accordingly disposed of.
May I please also, in first half list we receive item number 34. We have wrongly stated that the counter has not been filed. Already counter has been filed.
We can't modify the order like this. You see, so many orders are being passed. We can't burden our stenographers like this. On the next day, you say that it was wrongly submitted. रोज का ऑर्डर इतना सारा ऑर्डर्स होता है, नहीं हो सकता. इस तरह से हम लोग इन लोगों को बर्डन नहीं कर सकते. You know, they are working since 12 o'clock at night.